on a complaint that alleges that on or about July 20th, 2025, location in Pittsfield Township, specifically that being Washington Avenue, that you did at that time had possession of drug paraphernalia. You understand that, sir?
This case opens quietly, but don't let the calm fool you. Because what starts as a routine misdemeanor hearing quickly turns into a layered courtroom showdown involving drug allegations, bond conditions, testing compliance, and a second, far more serious matter that completely changes the tone of the room. We're in front of Judge Simpson, and right from the start, you can sense that this court is not here for confusion, excuses, or half answers. The defendant appears uncertain, even dismissive at first, claiming he doesn't understand what drug paraphernalia even means. That alone sets the stage. Courts don't like ambiguity when it comes to charges, especially when those charges can escalate quickly based on compliance. What we're about to see is how small decisions, missed tests, unclear prescriptions, and loose explanations can snowball into real consequences. And here's the hook. This hearing isn't just about one charge, it's about trust. Trust between the court and the defendant, trust between supervision and compliance, and later, trust when it comes to protecting children. Pay attention to how Judge Simpson handles patience versus accountability, because that balance becomes the backbone of every ruling you're about to hear.
No, I don't, sir.
Pardon?
I have no idea what this is about with paraphernalia.
Okay, so you have a complaint that alleges that on the date I just said, at that location, they're alleging that you were in possession of drug paraphernalia. I'm not asking, not saying whether or not you did it. You understand what you were charged with?
Yeah,
Do you understand what you were charged with?
I do today. Yeah, actually.
Okay.
I was being charged.
And that is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, and the court could order any substance abuse treatment. You understand that, sir?
Yes, yeah, sure.
You understand that?
Yeah.
Do you wish to be represented by an attorney?
Absolutely.
At this point, this is a public defender case. And then somehow or another, they'll make the magical switch somehow or another.
For the time being, Assistant Public Defender Natalie, and on behalf of Ms. Party, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered, and we would ask for an adjourned pre-trial date.
Then have a waive formal reading standing mute. The court will enter a not guilty plea. Pre-trial in this matter will be adjourned. Did they say how fast they can make things happen? They can make it happen, brother.
They didn't say, Your Honor. I don't know.
All right. Why don't September 17th, will that work?
Works for me, Your Honor.
All right. I'll adjourn it out to September 17th, 2025. And as to your other matter, you want me to adjourn it to that same day?
Yes, please, Your Honor.
All right, so we'll adjourn this one to September 17th. Let me set bond conditions on me. Pardon? I don't know that that's a violation, is it? So we got a problem. They've listed it as a progress report, but on August 1st, did a 10 panel, or was supposed to do a 10 panel. He missed his test, stated he didn't have money to do it at the time. On August 4th, he did a 10 panel. Problem is, he came up positive for amphetamines. And he denied having any current prescriptions that would have shown that.
This is where the hearing shifts gears. A missed test is one problem, but a positive result without a verified prescription is a much bigger one. Courts treat drug testing as binary. Either you complied or you didn't. Either the substance is authorized or it isn't, and Judge Simpson makes it clear. He's not getting caught up in date disputes. The issue is presence, not paperwork confusion. The defendant's explanation that he's been taking amphetamines since childhood might sound compelling emotionally, but legally, it means nothing without documentation. Courts don't operate on history or habit. They operate on proof. Lost prescriptions, changed doctors, and verbal explanations don't protect you from bond violations. This is a key lesson. Supervision conditions are strict liability in practice. Intent doesn't matter nearly as much as compliance. Would you expect the court to give leeway here? Or is the judge right to draw a hard line when public safety and supervision are involved?
Can I speak to me?
Pardon?
I called them and I asked them what I should do if I should come in and test them first. And they told me, don't worry about it and call back the next day. And I called back and then I think the days are messed up. It's like the moment I went and saw them, I went and tested.
What do you mean the days are messed up?
Because you said it's from the 1st and the 4th. And it was only a day after that I'd spoken with them.
I'm indicating what this says. I wasn't there. Okay?
Yeah.
So I'm telling what it says. I am not so much concerned about the dates. I am more concerned about why you have amphetamines in your system.
I've been taking Adderall since I was 7 years old.
Did you tell them that you have a prescription? Do you have a prescription for
I
it?
lost my prescription, sir.
Pardon?
I lost my prescription. I had to change doctors. Me and him got into it. So I even had the doctor's note from him saying that you can no longer, prescriber. Complicated story. Me and him got into it.
So you don't have a prescription?
No, I no longer have a primary care physician.
All right. Here's what I'm going to do. Sometime between now and the 17th, he needs to get back on and have his testing as he's supposed to have it. I'm not going to sit up here and argue with him tonight. Because I don't know, he knows what he's eating. I don't want to see those amphetamines unless he has a prescription in the system. Otherwise, I'm just going to make it real clear to you, I'll revoke your bond and you'll sit in jail until we get this thing done.
Judge Simpson's tone changes here, and that's deliberate. This isn't anger, it's clarity. He's drawing a boundary so there's no misunderstanding later. Courts hate ambiguity when it comes to bond terms because ambiguity creates excuses. This warning serves two purposes. It gives the defendant one last opportunity to comply, and it protects the court's authority if things go sideways. Weekly testing, no substances, no weapons. These aren't optional suggestions. They're conditions of freedom. And the judge is making it crystal clear that the next violation won't result in another conversation. It'll result in custody. Ask yourself this: is the judge being lenient by allowing continued release or strict by setting such firm expectations? From a legal standpoint, this is actually restraint. Many judges would have remanded immediately. Instead, Judge Simpson gives a final warning, and those are often the most dangerous to ignore.
Okay. Am I clear on that?
Yeah, I was just saying he's no longer prescribing me.
Am I clear?
Yes, sir.
I don't really need any more language from me.
Yes, Your Honor.
Bond in this case at this time will be set as $10,000 personal recognizance of lower standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or illegal drug use, no possession of any weapons. I will sign a new community corrections order. I want him for testing. I want him tested once a week. All right. Thank you.
Thank you, Your Honor.
Public Defender Alexis serves on behalf of Mr. Thurman, who's approaching.
Olin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him.
Now we enter the second phase of this hearing, and it's far more serious. Housing instability while on bond is one of the fastest ways defendants end up back in custody, even when they're trying to comply. The court isn't punishing him for losing housing, but it must ensure that any new placement does not violate existing conditions. This is where defense counsel attempts a workaround: supervised presence around children. But listen carefully to Judge Simpson's reasoning. Supervision in the legal sense doesn't mean someone might be around. It means structured and forcible oversight. Courts cannot rely on informal promises when children are involved. especially when the underlying case already raises concerns. This is the tension, fairness versus protection. And once children enter the equation, the scale shifts heavily toward caution. Do you think the court should prioritize stability for the defendant or absolute risk prevention, even if it means custody?
He, in a nutshell, has a place which he can be released to. However, his release to that place would be in violation of his current bond conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release, his contact with his own children of that other relationship is only supervised. Right. So and I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that.
This moment is subtle but powerful. Judge Simpson isn't accusing, he isn't escalating. He's explaining his discomfort, and in judicial language, that matters. Judges are bound not just by law, but by risk tolerance. Once a judge states discomfort on the record, it signals that any harm later could have catastrophic consequences for everyone involved. By refusing to tweak the bond, the judge is protecting the integrity of the court. He admits he doesn't know enough, and that humility is intentional. Courts don't guess when children are involved. They pause, they pass matters, and they force alternatives. This pause to the 3-0 block is actually a lifeline. It's the judge saying, I don't want to lock you up, but I won't gamble either. That's a razor-thin line. Would you have taken this opportunity seriously, knowing it might be your last chance before custody?
Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm going to do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions. When I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions in this case. I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3:00 block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay.
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock. My last.
Assistant Public Defender Alexis Jefferson on behalf of Mr. Thurman.
All right. And this is a recall. Were we able to make any progress?
Your Honor, I believe I will be renewing my request to allow him to be tethered to his mother's children's house. So it is my understanding that allowing him to stay there would not be a violation of his current bond conditions because he is allowed to have supervised visitation with those children. And at this time, he will always be supervised.
Well, no. Because as I understand the bond conditions, he's not to have any contact with any children. Was the exception to that were the children that were the alleged victims in this case?
No,
Your Honor, if I may clarify, I don't know if this was entirely clear earlier. The alleged minors involved in this case are not actually Mr. Thurman's children. Those are the
Right, correct.
children. He does not
No,
share
you're
those.
right. I misspoke. But he wasn't to have any contact with any children. The two other children, there was an exception for supervised visitation.
Correct. And Your Honor, my argument is that that is what he'd be partaking in by residing in that home. There would always be another individual present in that household. The children's mother takes the children to her parents' house during the day while she's at work. She picks up those kids, brings them home. Mr. Thurman would be obviously home by himself without the kids there. They would be at the parents' house, the grandparents' house, and then the kids would return with the mother. So the mother would always be present during those interactions.
On the record, we would be objecting to that, given the fact that we can't make sure that that happens all the time. And I would have great concerns of him being around children and living in a residence with the children, given the facts of the case. So we would be objecting for that reason.
And Your Honor, respectfully, even with the condition that he was allowed to have supervised visitation, there'd be no way to guarantee that that was taking place in the first place either. Your Honor, all this is being based off of right now is a 4-page police report. We did just receive some media discovery. I believe there's more to come based on a search warrant, but all of the information I have doesn't show that he's a danger to children at this time, especially his own children. Again, Your Honor, the children's mother is present in the court. She is willing to attest that she is perfectly okay with this arrangement, not feel unsafe leaving or having Mr. Thurman around their children.
Your Honor, I just have concerns given the facts of the case, even though it's much to the police report, we have a search warrant coming, but the facts of this case are that he put a camera in the bathroom that recorded the victim, her brother, and her children, and he sent those videos, including the children, to their father and other family members and other people, and the videos were of them using the restroom. I mean, I have concerns. The victim said that he admitted to her over text that he had more images, and when she confronted him about this, it became physical, and he was grabbing her necklace, breaking it.
This is the most disturbing moment of the hearing, and it completely reframes everything that came before it. Once allegations involve surveillance of children, recorded images, and distribution, the court's obligation shifts dramatically. At this point, bond isn't about convenience, it's about containment. Notice how the prosecution doesn't exaggerate. They simply lay out facts, and those facts are enough. The judge's earlier discomfort now makes total sense. Housing near children is no longer a gray area, it's a hard stop. Even supervised visitation becomes questionable when the allegations themselves involve privacy violations. This is why judges err on the side of caution. Even if charges are pending, even if discovery is incomplete, the potential harm is irreversible. Ask yourself, if the court allowed flexibility here and something went wrong, could that ever be justified?
Bit her arm, scratched her, and I mean, I have concerns given that this case does include surveilling children and sending those images to other people.
And Your Honor, without getting too much into the facts of the case, it's my understanding that Mr. Thurman filed his own police report a week prior to this police report being filed involving the complaining witness. He did provide a copy of that police report to me, and we do have that in our files. If Your Honor is unable to let him reside with at the home of his mom.
I passed this matter so you could find alternative arrangements. I've heard all of this.
And Your Honor, those are
The
alternative.
way that it's going to work. Either he finds alternative arrangements or he's going back into custody.
And Your Honor, those other alternative arrangements, the only thing they were able to work out is putting Mr. Thurman up into a motel. They do have a location picked out, and they have confirmed that there is rooms available at that location.
Then I'm not gonna have a problem with that either. Is that what he's gonna do?
If Your Honor is not letting him,
I am not, I think I made my position real clear when we were at the bench. And I think my face, if not tone, is making it very clear as to my interpretation of this order. And no matter how many times someone goes to say it, the crux of the order is he is not to be around children. There are 2 exceptions. I'm not creating other exceptions.
And Your Honor, we would not object to the motel.
Your Honor, then I believe at that time that is what Mr. Thurman will be proceeding with.
He'll need to submit that address of the motel within 24 hours to the court and to community corrections. Then he can do that. And you're requesting an adjournment of these proceedings?
Yes, Your Honor, I'd be asking for the closest possible date.
The what?
The closest possible date that Your Honor can accommodate.
August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. And is an email to your staff sufficient for providing the address? Thank you.
This hearing ends without a final resolution, but with very clear boundaries. Judge Simpson continues bond, but only under strict conditions, rejecting any expansion of exceptions involving children. The defendant avoids custody for now, but the margin for error is gone. Every future decision, testing, housing, compliance, will be scrutinized under the shadow of these allegations. From a legal standpoint, this was a textbook balancing act. Due process preserved, public safety prioritized, and discretion exercised without overreach. But make no mistake, this case is moving toward far heavier consequences depending on what discovery reveals. If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns that expose how real justice unfolds step by step.